The court. My name is Ted Green, and I represent Alexis Mack, the plaintiff appellant in this case. This appeal involves a case where the trial court granted summary judgment against my client based entirely on her rejection of the back half of a two-part settlement offer that Hyundai made after she'd tendered her 2016 Hyundai Sonata for repair 8 separate times, after the vehicle sat unrepaired at Hyundai's dealer for 245 days without a working engine, after she called Hyundai multiple times herself, after she retained counsel and we sent them a formal written notice letter that we represented her and outlining her claims, and after she tried to resolve her claims through Hyundai's mandatory informal dispute resolution process outlined in its warranty, and finally, after she filed suit. And focusing on that last part first, the settlement offer at point was a two-part. The first was a cash and keep offer of $5,000 to settle Ms. Mack's legal claims against Hyundai, or in the alternative, Hyundai said they would do a lemon law buyback, and they didn't provide any of the financial terms of that buyback, that is the actual numbers, but they did have more than a dozen outlined requirements that would have gone with it, including my client's execution of a settlement agreement and release, which would have obligated her to indemnify Hyundai in ways that were vague and amorphous and could have had her owing them money in the long run. In short, the trial court granted summary judgment because Ms. Mack rejected a secondary settlement offer, which was for relief she didn't even ask for, which was not available under the Magnuson-Moss Warranty Act, the only law she sued under, and which, even if it were available, both the Lemon Law, which does not apply to this case, and the Magnuson-Moss Warranty Act, which does apply to this case, expressly say my client has an unconditional right to reject if she's not satisfied with it. And we know that this was a settlement offer, and this is key. The trial court thought it wasn't a settlement offer. That was its finding. There is no reasonable way the trial court could have come to that conclusion. First of all, Hyundai, when it asked us to enter into negotiation—
Before you go into that, Mr. Green, let's assume that instead of a settlement offer, it is treated as a reasonable opportunity to cure, as the judge in the lower court did. Having given the Hyundai all those opportunities to fix the car, does she bound by the offer as a reasonable opportunity to cure, or can she reject what they have offered as an opportunity to cure and rely on her other opportunities to cure that she has given?
The answer to that question, the short answer, is yes, she can rely on other opportunities. And the reason—
That's all I need. If you want to give a longer one, but we can talk about whether it's a settlement offer. But
so just in case somebody else on the panel has this question, here's why I say the short answer is yes. The Lemon Law, which again does not apply here, and the Magnuson-Moss Warranty Act, both of those statutes expressly give the consumer the option to pursue all other rights and remedies under any other law that's available. So the option is my client's. Now, if we go in a little bit further and we look just at those acts, so let's assume for the sake of argument, and it isn't true, but just for the sake of argument, that my client is limited to one of those acts, and she's not, because they both allow other claims. Both of those acts expressly say that it is the consumer's option what relief they accept. In fact, the Magnuson-Moss Warranty Act— so I'm trying to make this simple, even though I am going a little bit further into it, because there's a lot to this, and I love this law. It's a cool law. There's a lot to it, and it keeps me fascinated. There are 2 sections to this act that a consumer could potentially sue under. The first is 2304, but 2304, and that section provides for certain express remedies. One remedy under 2304 would be a repurchase of the vehicle, but there is no mileage offset under the Magnuson-Moss Warranty Act, where there is under the Lemon Law. And even that section says the consumer has the option of pursuing 3 different types of remedy: repair, and that repair could be of the entire vehicle or only of the defective component, a replacement vehicle, or a repurchase. However, 2304 doesn't apply because manufacturers don't give full warranties. And they don't give full warranties because it would expose them to the liability of having to swap the vehicle at the consumer's choice or do a buyback. So they limit themselves. And in fact, Hyundai's warranty is designated on its face and repeatedly throughout as a limited warranty. And the reason it's called a limited warranty is they've limited their obligation under the warranty to one thing and one thing only, and that is to repair the vehicle. So if you have a limited warranty, the consumer has to seek their remedies under Section 2310. Under 2310, the consumer is entitled to pursue damages and other legal and equitable relief. Courts uniformly across the country have said that the consumer's measure of relief is primarily, and I'm going to limit this, it is a neat law and I love it, but limit it for the purposes of this. And this court has said recently in Kia v. Dowdy, which we cite in our brief, that the consumer's remedies under a limited warranty derive from the Uniform Commercial Code. And the primary remedies are diminished value, which is measured at the time and place of acceptance, the difference between the value of the vehicle as delivered and as warranted, and incidental and consequential damages. Those are the 3 we focus on. Those are, by the way.
Let me, I'm teasing out.
Yes, sir.
Which, it's kind of like we're at a cocktail party. Anyway, and I'm sure you discuss this a lot at cocktail parties. Anyway, so the statute 2310 requires the claimant to give the person obligated under the warranty a reasonable opportunity to comply, to cure such failure to comply. Could that include repair and, if the automobile was repaired, would the claimant still be able to then claim consequential damages for the time that it was out of service and so forth?
So I want to make sure I answer your question.
I mean, I guess what I'm saying is if the warrantor repaired the vehicle, would it now be shielded from suit, having taken that reasonable opportunity, or could it still be liable at that point for consequential damages and diminished value and so forth for the failure to comply in the first place?
Yes.
Actually, Mr. Green, I'm sorry, but before you answer that, can I take it a step back even further? Are we just looking at the engine? Does the claim arise out of the engine, or is it all these other things that your expert has later identified? I want to make sure I know exactly what we're talking about.
So it's a catalog of defects, and I have to say I don't recall each one, and I know if I'm going to make a factual representation, I want to be accurate. Actually, I have the complaint in front of me, so I could tell you. So we pled in the complaint the defects, and that's at paragraph 12. So I'm going to turn to 14, and I'm going to turn to that, and here's what we were suing on. My client was dissatisfied with these categories of repairs: defective engine and or electrical system, as evidenced by, and we list the ways it manifested; defective transmission, as evidenced by a jerking condition when accelerating; defective steering system, as evidenced, and we outline why; and defective body and trim, as evidenced by missing molding under the hood. And that missing molding is not just cosmetic, it relates to repairs that Hyundai's dealers performed on the vehicle. So that's the universe of defects that we sued under. Having said that, and I often point this out to a jury when we get that far too, I think it's accurate to say that my client, if she'd had a vehicle that actually gutter places, she probably wouldn't have filed suit. It is accurate to say her overriding concern is that this vehicle had an inoperable engine that she had to bring back. And I believe for the engine, she was in for 9 separate repairs, I believe 8 of them pre-suit. And I believe 7 of those involve the engine. So the engine is overwhelmingly the problem.
If I recall correctly, the warranty related to was the drivetrain warranty. Is that the engine and drivetrain?
Actually, in this, so it does have an engine and drivetrain, and that did cover it. It also has a bumper to bumper, and that's a colloquial term.
Yeah.
But if the defects occur within the bumper to bumper period, that generally covers them. They could be arguably covered by the drivetrain, but there's overlapping coverage. And in this particular case, all of the defects, all of them, manifested within the initial bumper to bumper period. So it could be either warranty, but they both have the same terms and conditions with respect to this case.
So for instance, the molding wouldn't necessarily be part of the drivetrain warranty, but would be bumper to bumper.
That's true.
Okay.
That's true.
I got it.
And our contention in the complaint is that they breached their warranties, and we use the term plural, their warranties on the vehicle. But you are correct, like the molding would be the bumper to bumper versus the drivetrain. So there's some overlapping coverage, and there's some differences that, for the sake of legal analysis down the road, if we got to a jury, which we should have, wouldn't have been relevant necessarily to their analysis. And I can say,
the question here is, did by, as a judge will, by turning down that $5,000 offer or whatever it was at that point, did you fail to give Hyundai a reasonable opportunity to cure the failure to comply with the warranties?
Now, you're almost right, and I'm glad you framed
I'm
it
quite
that way.
often almost right.
Well, the reason that you're almost right is that the judge never considered, and Hyundai has never explained. So when they made their first settlement offer, they asked, actually stepping back, they waited. I said my client gave them 245 days on the 8th repair alone to repair the vehicle. So the judge dismissed that and said, well, that's not a reasonable opportunity to cure because you didn't accept this settlement offer. And we said, and I said, was one of the ones that argued it, in addition to that, when we served our notice letter, we gave them 56 days before we filed suit. They didn't respond initially at all. In fact, I think it was for 49 days. Again, I want to be clear when I'm making factual representations. I believe it's 49 days before they responded. When they did finally respond, they asked us to provide them some documents. They looked at those for 2 days, and then they came back to us with an email, and this is page 2055 in the record. Please let me know where your client stands settlement-wise. So we made an initial settlement demand, and I'm getting to your question. I know I apologize. So you said the trial judge thought by rejecting that $5,000. No, their initial settlement offer was $5,000 and we keep the vehicle and we're all done, or we'll buy your vehicle back under the Lemon Law, something we hadn't even asked for at that point, either in our notice letter or later in our complaint. The judge ignored the $5,000 cash and keep, and she looked at it like they only did one thing, and that was offer to do a Lemon Law repurchase. And since you refused that, you didn't give them a reasonable opportunity to repair.
Let me ask you, your answer there touched on something I had a question about that I didn't frankly have an opportunity to dig into. You said the notice letter. In the MMWA scheme, is there a notice required, a written notice required, or was that the notice letter just basically a demand letter? It
was a notice letter.
Okay, and is that required under the scheme, in the statutory scheme?
No, it's not.
Yeah, that's
a rhetorical question that I'm going to answer. Do you know why we send that notice letter?
Sure.
Because I have been in front of juries before, and the other side says they never even gave us a chance to, they didn't even tell us they had a problem. So
But from your position anyway, under the Magnuson-Moss, once she brings the car in for repair and leaves it, 245 days the last time around, that was a reasonable opportunity to cure the failure to comply, and she was good to go in terms of that condition preceded.
That is my position.
Okay.
Now,
You didn't mention whether you wanted to reserve rebuttal time, but you are 15 minutes into your argument at this point.
I would like to reserve 5 minutes if I'm able.
Okay.
I'll answer any questions, but otherwise I'll stop talking for now.
All right, that works. Okay, Mr. Shelton.
Morning, Your Honor. David Shelton on behalf of Hyundai. May it please the court. There were a couple of questions asked about bringing the vehicle into the dealership, and we certainly differentiate between the dealership and Hyundai because Hyundai is the party that's obligated under the warranty. They're the warrantor for purposes of the Magnuson-Moss Act. So taking it to the dealership.
Doesn't the, and again, I may not remember this scenario correctly, but doesn't the warranty say take it to the dealer?
That's correct. That's
And
how the warranty
she had called Hyundai, had she not?
She had made some calls to Hyundai, but those were not the opportunity to cure.
And did Hyundai approve replacing the engine?
I'm sorry, I didn't hear that.
Was there an allegation or evidence that Hyundai had to approve the engine replacement or somebody up the line?
Yes, and her vehicle was in the dealership waiting for an engine at the time, but the statute, the Magnuson-Moss statute says that the warrantor has to be given an opportunity to cure. And Mr. Green
is calling Hyundai and say, hey, my car is really screwed up, and the dealer gets permission from Hyundai to replace the engine. Doesn't count against Hyundai's responsibility?
I think in a general sense it could, but for purposes of our case, as Mr.
Well, for
Green
purpose of
conceded,
your case, which is like was it a motion for summary judgment or a motion to dismiss?
it was a summary judgment.
Yeah.
But for purposes of our case, they gave a notice letter. That's what Mr. Green keeps calling it, and it's the notice letter that triggered all of the response to that. That was the first notice.
Oh, really? You didn't have anything? Your company had nothing in its files about this car, or maybe should have in any respect?
The affidavit that was filed with the summary judgment motion attested to the fact that the notice letter, the formal notice letter, was the first notice to Hyundai that the dealership efforts to repair were inadequate and not being accepted by the consumer. And so it transitioned from being a problem that the dealership was handling to a problem that Hyundai was dealing with. And that's where this whole concept of curing the problem. I mean, they want to argue.
Let's come back because the judge said, hey, that $5,000 offer was a reasonable opportunity to cure. And because she accepted it, she did not furnish a reasonable opportunity to cure. Now, how do you get from one to the other?
I disagree with Your Honor. The trial judge was very clear.
I was looking at the order. Just a few minutes.
It's on page. It's on page 1610 of the record on appeal, and the trial judge was very clear in her explanation. She said the refund offer was a cure of any alleged warranty breach. She didn't say the $5,000. She's talking about the refund offer.
The refund offer, and I've asked Mr. Green, if she takes that money or if they fix the engine, can she still sue for consequential damages? His position is yes. So how does the judge decide that the refund offer of the $5,000 and what have you is enough?
Again, Judge, the focus of the litigation below was not about the $5,000. The focus of the summary judgment was the fact that we agreed to repurchase her vehicle, not to pay her $5,000, but to repurchase her vehicle.
Under the lemon law.
Well, that's the calculation we started with, but it wasn't just a lemon law refund, which is the way they want to characterize it. But I would point out that they never objected to the lemon law calculation at the time. There was no contemporaneous objection at the time. This is just something that they're raising now in opposition to summary judgment. But we started with the lemon law.
Because what they're saying is this was a settlement negotiation. It sure looks like one to me.
Well, and
particularly since the offer was after the suit was filed. So it wasn't a situation where there had been a failure of the condition precedent before the filing of the lawsuit.
Well, the notice came in and was received by Hyundai in early May. And when these negotiations were going on, and I I think the trial judge was correct to view these as part of the reasonable opportunity to cure. I mean, it may look like settlement negotiations, but that's what the statute says. It says we have a reasonable opportunity to cure, and Congress indicated that they wanted to avoid warranty litigation by giving this last opportunity.
Is
And so,
Hyundai conceding the breach?
no, and that's why this case only got litigated on the condition precedent. We never went to the next step as if she satisfied condition precedent, whether or not there was a breach, and if so, whether there were damages. None of that's part of the record because it wasn't litigated because of this fundamental issue with respect to the breach of the condition precedent. And that's all the trial judge found. She said the refund offer was a cure, and by rejecting the refund, plaintiff failed to satisfy the condition precedent. That's the entire ruling. And the proceedings were focused entirely on the repurchase offer and not on the $5,000. I mean, that was included in the initial email, but if you look at the record, all of the communications after that, up until the point where the repurchase offer was rejected, related to the repurchase. And during those times, Hyundai made it very clear that they were starting with the lemon law methodology to calculate the repurchase. And there was never an objection. There was no contemporaneous objection that, no, we shouldn't use the lemon law methodology. But we pointed out in our brief that we didn't stop with the lemon law methodology, because if we had stopped there, she would have owed thousands of dollars to her lender for purposes of paying off this vehicle because she had such a high negative equity in the vehicle when she bought the Hyundai. And so we went above and beyond that, and we said, we're going to start with the lemon law. We made it very clear from the very first email that we were willing to absorb all of that negative equity, even though the lemon law says we don't have to do that. So we used the lemon law as a starting point, but it wasn't the ending point. And certainly other courts have looked to state law. They've looked to lemon law for purposes of filling in the gaps when there is something about the Magnuson-Moss that isn't set forth. And Mr. Green is right that most of the statutes that deal with a warranty deal with full warranties, which is not what we have here. So a lot of what he was saying deals with the procedures and the process under full warranties, but we don't have that. We have very limited parts of the statute, parts of the Magnuson-Moss that deal with this. And if you look at the way 2310, which is the particular part of the Magnuson-Moss that they're traveling under, the Congress made it very clear in the very first section. They said our policy is for these consumer disputes to be fairly and expeditiously settled through informal dispute resolution mechanisms. And then in paragraph 3 of 2310, they set those up. And then lastly, they set up this provision E that sets up the reasonable opportunity to cure. So Congress went out of their way, even though they created this cause of action, this statute that has a cause of action, they went out of their way to set up procedures and processes so it wouldn't get to that point. And that's what we're traveling under.
Let's accept that that's a reasonable opportunity to cure, and it failed. Why does she still not get to sue? It failed because she would want her Magnuson-Moss remedies, which would include incidental and consequential damages. So why then the fact that attempt to cure failed, why is that? Was that the judges said it was a reasonable opportunity? So how come she's kicked out of court for failure to comply with the condition precedent?
Because the repurchase offer that Hyundai made her whole.
That's in the judge's view.
No, that's under.
Wouldn't that be a question of fact for a jury? Wouldn't that be a question of fact for the jury?
No, it was never contested that it made her whole in the sense of paying off her loan, which is what I was saying before, is that we went above and beyond the lemon law and we agreed to pay off her negative equity. So she got paid off. And we outlined in the brief, I mean, they've come up with this argument that, well, she has some right to reject even a reasonable offer. an offer that makes her whole, their position is we have an absolute right to do that. But if you allow that, then you're not following the congressional intent, which is to avoid the warranty litigation. You're allowing the plaintiff to say, yes, I would be made whole by this refund, but I don't want to do that. I want to go to litigation instead. And we pointed out in the brief that at the time this repurchase offer was made, she was $15,000 in debt. She calculated her damages to be a little over $10,000, and her expert calculated the value of her vehicle at that time to be a little over $2,000. So if you do the math, under her view, she would have been $2,700 in debt at the time. We offered her a full repurchase that allowed her to walk away from the vehicle, walk away from the loan where she had all this negative equity. And that's what was going into the trial judge's mind when she heard about this refund. And that's what gets into, in this particular case, we have litigated this case from the perspective of the reasonable opportunity to cure, and it has to be given to the warrantor. And the only opportunity that we got was this formal notice letter. And as we point out in the briefing, the notice letter asked for repurchase.
It never sent the notice letter. Would you be saying you didn't have a reasonable opportunity to cure? Or could there be evidence that, for instance, Hyundai, she talked to Hyundai directly, the dealer asked permission to do an engine replacement? Would that have been a reasonable opportunity to cure?
No, that is continuing with her warranty obligations. At some point, the way the Maxim Moss is set up, at some point, she gets to say, we're through with the warranty, and now we want to go into litigation.
Right, and at that point, if she had filed suit after she gets the car back after 245 days and said, you know what, I got the engine in the car, but I'm still have some damages that flow from your failure to keep this car running for, where you're keeping it tied up for 245 days, and I want that. And haven't you already had the reasonable opportunity to cure at that point?
Under your hypothetical, I don't think so, because the vehicle was there in the dealership waiting on the engine at the time these cure communications happened. And I would point out that your hypothetical proves our point that one of the fundamental things the parties have disagreed about is whether or not we can repurchase the vehicle as part of the cure opportunity. And we certainly have outlined the reasons why we think that's true.
I think you certainly can. But the thing is that does she have to accept that or have her suit thrown out for failure to comply with a condition preceded? After she has brought the car in, 9 times, it sat there for close to a year before the engine, while it was waiting on a new engine. She's talked to Hyundai. Couldn't a jury find? She gave Hyundai a reasonable opportunity to fix this situation, to cure the failure of the warranty.
Again,
just based on those facts, because Mr. Green says there's no notice requirement in the statute.
But they gave notice, and that's the important one.
They gave you more than you were entitled to.
That's what I'm saying, is that we have to deal with our case on our facts, and our facts is that they decided to give us a formal warning notice, and we responded to that. And
I think what they did, in my parlance, which is not admittedly Magnuson Moss, it was a settlement demand.
I think it goes beyond that, but again, the reasonable opportunity to cure is an opportunity to resolve this. If you want to use settlement instead of resolution, I understand that, but you're still getting to the point that Congress said we want that to happen. We don't want warranty litigation.
The judge gets to decide that the settlement was reasonable and she should have taken it, and since she didn't, she can't file suit.
Under these facts, yes, particularly when we made the repurchase offer, there wasn't any objection made that she wanted to have it repaired. There wasn't any objection made that we couldn't use the lemon law methodology. There wasn't any. Ultimately, when they said no, they didn't offer any explanation. They just wanted to go into suit. And our view is that the repurchase needs to be our choice, not hers, just for the reason that you're suggesting, Your Honor, because this finally resolves the dispute. Because like you said, we replaced the engine, she was still dissatisfied. But if we buy it back and we pay off her loan and she has no obligation, she doesn't have to worry about being dissatisfied with a new engine. She doesn't have to be dissatisfied with repairs. She has been made more than whole, in my view. And that's the problem. That's what I think persuaded the trial judge, is that here she chose to go to litigation, even though this offer was so much in her favor that it would have gotten her out of this car. The formal notice letter says she didn't want this car. She revoked acceptance. She didn't want to drive it anymore. It was fraught with apprehension. She did not want it to be repaired. Mr. Green's position in the briefing is that was our only response, is to say, yeah, we'll try to keep repairing it, but there's no way for us to cure the problem under these kind of scenarios unless we have the ability to repurchase it. So we certainly ask that the court clarify in its order, in its ruling in this case, that we have the right to repurchase a vehicle, particularly when the formal notice letter comes in and asks for it to be repurchased, because that's a fundamental dispute that we have in this case. And there's certainly other cases out there where this would be important, but that's an important part of what the trial judge ruled. And it's an important part of the development of the law in this area, is that we need to be, the right to repurchase needs to be recognized as part of the cure based upon a reasonable interpretation of that language in the statute. And we shouldn't be just limited to repairing it, continuing to repair it in order to avoid the warranty litigation, particularly like we have here. Court has no other questions. We certainly will stand on our briefs with respect to the other issues.
Shelton, Mr. Green, you got 5 minutes.
Thank you. So first of all, let me start with this. What Hyundai is asking this court to affirm is that it has the right to force remedies of its choice on my client where the law does not force them. And by the way, nowhere in the law that I'm aware of does the party that does the injuring get to decide what makes the injured party whole. But that's what Hyundai's asking here. The
Mr.
other
Green,
thing,
Mr. To that point, is the objection that you have with the repurchase of the vehicle, or is it with the repurchase of the vehicle as the sole remedy? Because you're alleging that there are all these incidental damages.
So I was pausing because I realize that the ideal is to give soundbite responses, and I'm trying to do that. My objection is that we engaged at their request in good faith settlement negotiations. He said we didn't object to the repurchase offer. We rejected the offer. We didn't have to outline our objections. We were involved in ordinary settlement negotiations, and my client decided that what they thought would make her whole would not make her whole. So my first objection is that we engaged in good faith in settlement negotiations, and now they want to use it against us, which the statute expressly says you can't do. My secondary objection is that my client decided that it wouldn't make her whole. They are concocting reasons after the fact that aren't demonstrated by the record. We never said, well, if you adjust it this way, that would satisfy us. We decided that what they wanted would not make my client whole. My tertiary objection, and I can go long, but I know I don't have that time, is that they proposed not just a lemon law repurchase. They conditioned that repurchase upon my client executing a long settlement agreement and release. And that's not my terminology of what I think it was. They call it a settlement agreement and release. And that settlement agreement and release is in the record. And one of the things it required of my client was that she indemnify Hyundai against unspecified claims on this vehicle brought by any other third party against Hyundai, its dealerships, plural, any dealership, or other employees, agents, etc. My client the law would never have made her, the law never exposed her to that level of liability. The law exposes Hyundai to liability, but they wanted my client to accept liability the law didn't require. And here's the other thing. Here's my other objection. If Hyundai really thought that their settlement offer was generous to my client, there is a procedural mechanism already in place that allows them to use it as a sword against my client. They could have filed a proposal for settlement outlining all of that. And then if we hadn't beat it when we went to trial, they could have come back to the judge and said, look, judge, we offered her something we told her was generous at the time, and clearly it was because the jury didn't give her that. My other objection is this, and I really am trying, I know it may not sound that way, but I really am trying to keep it short. You know,
You're going to keep it to 5 minutes no matter what.
I understand. Judge Northcutt asked this. He asked about the incidental and consequential damages. And what if we had taken a lemon law repurchase? Would we still be able to pursue those under the Magnuson-Moss Warranty Act? That's a hypothetical in this case, but I had that case. Burns v. Daimler Chrysler, which I cite in my initial brief. We actually won the lemon law arbitration, and the other side, Daimler Chrysler, was ordered to buy back the vehicle. But my client still had incidental and consequential damages. And the Fourth District said, hey, you can get a lemon law buyback and still pursue your incidental and consequential damages. If you're not made whole, because both of these statutes allow you to pursue all of your rights and remedies, you can do so. So Judge Northcutt's question in this case is a hypothetical, which proves our point, but I've had that very case in Burns v. Daimler Chrysler, where the appellate court answered that question and said, look, a lemon law repurchase doesn't extinguish their, and I think it was a Mr. Burns in that case, doesn't extinguish Mr. Burns's claims.
Let me ask you, let me come back though, and because so I can understand the two perspectives on this notice, this notice that you sent. The other side seems to suggest that was the beginning of their opportunity to cure. And your position is the Magnuson-Moss Act doesn't require any such notice. And the opportunity to cure was previously all those times the car was taken in and calling Hyundai and permission to replace the engine and so forth.
Yes, and here's why, and this is a critical point. The Magnuson-Moss Warranty Act requires my client to do two things and two things only: to comply with the terms of the warranty and to allow the warrantor a reasonable opportunity to comply with its obligations under the warranty. Their warranty tells my client, just take it to the dealer. Additionally, if my client is dissatisfied with the dealer's repairs, it has a three-step process. Do you know what the first two steps of those three are? Hey, go back to the dealer and talk to them. And the third requirement imposed upon my client is give us a call and let us try and work it out. My client called them 5 separate times, and each time she called, they said, there's not much we can do for you. I'll tell you what, take it back to the dealer. We'll let them know you're coming. Okay. My client complied.
5 minutes, Mr. Green.
Yes, sir. Yes, sir.
All right. Thank you both very much.
Thank you, Your Honor. Thank you. Thank you.
In order to leave our virtual courtroom, you click the leave button of all things in the lower right-hand corner of your Zoom screen.